Major breaking news out of the Southern District of California. Judge Roger Benitez has declared that California's ammunition background check system, which requires one to go and get a background check every time you procure ammunition in a face-to-face meeting with an ammunition dealer. Guess what? Judge Benitez just declared that is unconstitutional under the Second Amendment and the Bruin methodology. Major victory here for the Second Amendment. Let's talk all about it when we get back. I think you're going to like the decision in Rode versus Bonta in 1 second. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the author of Disarmed, What the Ukraine War Teaches Americans About the Right to Bear Arms. Stay tuned for a big announcement about my next Second Amendment book shortly. All right, major victory here. Happy to say Judge Benitez has declared on a final judgment basis and has entered a permanent injunction that California's ammunition background system is unconstitutional under the Second Amendment for a variety of reasons. Just as jog your memory, the way the law works is if you want to buy ammunition, you have to get a background check as if you're buying a gun. Judge Benitez says this is unconstitutional under the Second Amendment for many reasons, one of which is, of course, there's no historical analog laws anywhere in point of time until literally after the year of our Lord, 2008. After the Heller decision, some of these outlier states like California started implementing these systems for background checks of ammunition. Judge Benitez says this is clearly unconstitutional under the NYSERPA versus Bruin standard, which is really the Heller-Bruin methodology. And he says this is no-go and has permanently enjoined these laws. We'll see what happens on an appeal. I'm sure California will take an appeal to the Ninth Circuit. I don't know how that's going to play out, though. It depends on the panel and the administrative law judge and whatnot, but we will keep you informed. The big decision, though, in terms of breaking down this decision by Judge Benitez, he specifically says that the attempt by California to rely on the language in Heller about how background checks are presumptively constitutional and that these are commercial transactions, Judge Benitez rejected all this. He said that this background check is no excuse to impose this kind of condition or qualification on the sale of arms. He says this is simply not possible to conclude this because there are no background checks on ammunition until after the Heller decision. So whatever the Heller decision stands for, it clearly is not dealing with questions about whether or not background checks on ammunition are constitutional because, again, they did not exist until after the 2008 decision in Heller itself. Number two, what's also very powerful about this decision is Judge Benitez really laser focused and pointed this out, that under even the Attorney General, this is good news for down the road, even the Attorney General of California admitted that ammunition is an arm for all intents and purposes because it essentially constitutes an ancillary right. Now, if you follow some of my articles in ammoland.com, I wrote extensively about this about a month or so ago, about how the Second Amendment's text has ancillary rights. And one such ancillary right is the ability to acquire ammunition. And Judge Benitez completely agreed. This is what he wrote. All agree that the ammunition necessary to use a gun is covered by the Second Amendment's protection for keeping and bearing arms. The Attorney General of California correctly concedes that even though the Second Amendment does not reference a right to acquire or purchase arms or mention ammunition, it protects ancillary rights necessary to the realization of the core right to possess a firearm for self-defense. The Attorney General of California agrees that the core right to possess a firearm for self-defense would include a corresponding right to obtain bullets necessary to use firearms for self-defense. Powerful language there in the Rode versus Bonta case. We will see that more and more down the road in other cases dealing with ancillary rights. The next powerful thing that Judge Benitez said is it was really kind of interesting. He's very good with analogies and metaphors. This is what Judge Benitez says. He says it's simply absurd to think that every time you have to refill your gun with ammunition, you need to get a background check any more than why would you need to get a credit check every time you purchase gasoline or plug in your electric vehicle to recharge it or to refuel it to continue to drive the car. This is what Judge Benitez says, a powerful analog or powerful analogy here in this Rhodes versus Bonta case. Judge Benitez writes, today a person may choose to submit to a full credit check to buy an automobile, but he is not required to pass the same credit check every time he needs to refill his car with gas or recharge his battery at a charging station. And the Constitution does not mention a right to own automobiles or carriages or horses. Similarly, when a person chooses to buy a firearm, he is required to undergo a full background check. However, until now, He was not required to also go through a background check every time he needs to refill his gun with ammunition. And the Bill of Rights commands that the right to keep and bear arms shall not be infringed. With the recently enacted ammunition background check laws, gun owners in California undergo background checks more than 1 million times each year simply to buy ammunition. Period, close quote. So Judge Benitez obviously thinks all of this is absurd. The other interesting thing, and this is not even part of the constitutional analysis, he really just goes to show that it's absurd to think that this background check does anything for public safety. Because specifically what he did here is he goes out and he asked, apparently during the trial of this matter and looking at the evidence, it turns out that, for example, when he looked at the 2019 year, that there were almost 1 million, I think it was like somewhere on the order of magnitude of 650,000 background checks that were conducted in the first 6 months of 2023. That's 538,000 background checks in the first 6 months of 2023. And of those, he said 58,000 individuals were rejected because of a failure to match the relevant record. And he goes on to say, these are citizens with Second Amendment rights to protect themselves who are blocked from buying ammunition. Then he goes on and breaks down and sees how many of these people are being denied because of a problem with the system versus the fact that they're not allowed to have firearms or ammunition. And it turns out that very few of the people stopped actually had some problem legally where they could not have guns or ammunition. This is what Judge Benitez writes. He says, of those same 583,000 persons who submitted to ammunition background checks in the first half, of those same 583,359 persons who submitted to ammunition background checks in the first half of 2023, only 0.03%, that's 141 individuals, were denied because they were found on the Armed Prohibited Person Systems list. The court asked, this is very interesting, the court asked the Attorney General to provide information about the ultimate resolution of the cases. And then, of course, I should say that Judge Benitez continues on. And this is what he concluded. Ready? Quote, to sum up, approximately 635,000 residents were required to undergo background checks in the last half of 2019. This is after Judge Benitez asked about a series of years. And the denials of which prompted the arrest of 15 individuals, which led to 6 criminal convictions. So here you have a situation where 635,000 people were required to undergo a background check in the last half of 2019. And yet of that, 15 individuals were arrested and only 6 were convicted. Not a good hit or miss, right? This is clearly about burdening law-abiding Americans, law-abiding Californians. It has nothing to do with public safety or crime control. Judge Benitez also takes to task California for trying to rely on racist laws. This is what the judge said. He basically says, in reviewing his history, he says that in his view, Judge Benitez's view, he's rejected over 50 laws relied upon by California that prohibited, quote, Negroes, mulattoes, slaves, or persons of color, or Native Americans from buying or using arms, characterizing these laws as, quote, a long, embarrassing, disgusting, insidious, reprehensible list of examples of government tyranny towards our own people. And Judge Benitez, threw these all out and said these are not analogs for denying American citizens the right to keep and bear arms. Judge Benitez also dismissed an attempt by California to use loyalty oaths at the time of the founding as a basis for denying people the right to keep and bear arms. Judge Benitez said that if people refused to take a loyalty oath at the time of the founding, they themselves were essentially declaring themselves to be not citizens, which is completely disanalogous to what we're talking about here today, which are California residents, citizens of the United States, being denied their ability to exercise the right to keep and bear arms shall not be infringed. And therefore, all these analogs dealing with African Americans, at the time, slaves, Native Americans, people that wouldn't sign loyalty oaths, none of these are analogous, and none of these can be used to deny Californians the right to keep and bear arms. Judge Benitez's opinion in Road versus Bonta is very powerful in that respect. The last observation is just how insane California was to try to justify this. Judge Benitez points out that the relevant time is around the period of 1791 through maybe the 14th Amendment, with an emphasis on 1791. He really obviously is clear that 1791, as we've talked about in the Harvard Journal of Law and Public Policy, that my article many of you have read, and we've talked about it on this channel, the relevant time period is the founding period. Now, Judge Benitez even, said, well, even to the extent you consider anything later than that, it's to be given much less weight. than this historical analog laws at the time of the founding. Nevertheless, this is kind of interesting. What California was so insane trying to justify this law involving ammunition background checks, and this is what Judge Benitez said, that the state of California went far beyond essentially what I asked for. The state produced a list of 148 laws, 148 laws covering 535 years. From 1403 to 1938, did you hear what I just said? California's Attorney General used 148 gun control laws or arms laws covering 535 years, starting in the year of our Lord 1403, going to 1938. Columbus doesn't even sail the ocean blue until 1492, and yet here you have California trying to rely on laws almost 100 years before Columbus even set sail to the New World. And yet, this is what California is trying to do. That's how desperate they are to take away the right to keep and bear arms of Californians. But anyway, in the short run, major victory for California gun owners. I'm not sure the Ninth Circuit is going to stay this. I'm not sure what they're going to do on this, but I will say this is a final judgment. That's extremely good news because whatever happens, it's a final judgment. It's not an interlocutory appeal up to, let's say, the Supreme Court as to whether or not the Ninth Circuit will play their shenanigans with en banc review and all the games they play out there to, hurt American gun owners in the Ninth Circuit. I'm not sure it's going to happen here. This may be one they let slide. Only time will tell. We'll see what happens, and we will keep you informed here at the Four Boxes Diner as things develop. All right, hope you learned something here today at the Four Boxes Diner. Make sure you follow me on X at Four Boxes Diner. A lot more Second Amendment information beyond what I can cover on the YouTube videos. And don't forget to subscribe and subscribe and subscribe again, because a lot of people are getting knocked off my subscription list here at the Four Boxes Diner YouTube channel. And again, we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.